Good morning, everyone. I would like to extend my greetings to our CEO and founder, Advocate Tiry, the SABWiL Alumni Executive Committee, the SABWiL Luminaries, SABWiL Alumni, the Johannesburg Attorneys Association, and the team, the guests, as well as all the stakeholders. Women's Day commemorates the Women's March that took place on 9 August 1956, where 20,000 women from all over South Africa staged a march on the Union buildings in Pretoria in order to protest against the proposed amendments to the Urban Areas Act. In honor of Women's Day, we pay tribute to the lives of these women and recognize the role of the women in the liberation of South Africa from the apartheid regime, as well as unjust laws. SABWiL and the JAA decided that the best way to honor such strength is through education and empowerment. It is against this premise that we decided to honor the women of 1956 by empowering us as legal practitioners with the kind of education and information that will help us in our legal careers. My name is Cleopatra Mahoa, and I'm the SABWiL South African Black Women in Law Alumni President, and I'm also the Program Director today. So first things first, I would like to go over some house rules, if I may. Kindly ensure that your mic is muted and that it remains muted and that your video remains turned off during the presentations until the question and answer session commences later. If I may also ask the speakers and the moderators to kindly leave their videos on for the duration of the webinar, please. Also, please note that in terms of the Personal Information Act of 2013, your personal information shall be kept strictly private and confidential because the POPI Act is upon us. With that, I would like to hand over to Hilda Eksteen to please bless us with opening remarks. Hilda, over to you.
Thank you, President. First of all, I would like to thank everybody for this opportunity and to thank everyone to having this awesome panel of ladies introducing us today to Court-craft Essentials. So first of all, I would like to start with the Constitution. So in terms of Section 34, you have the access to court. Everybody has the right to have any dispute that can be resolved by the application of the law, decided in a fair and public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. At the end of the day, this means that all of us will have the right to be in front of court. You have the right to bring your matter to a court and to be heard. So just to give you guys a bit, or ladies, a bit of a background of our South African law, I'm quite sure everybody knows we are based on the Roman Dutch law. So what I would like to introduce you to today is, I don't know if everybody knows this, but at the back of an advocate's robe, you get a small triangular piece of material. And that is, this is cut in two pieces, and it hangs at the back of the left shoulder. So the origin to this piece of triangular material is quite obscure. There are two theories. So the first theory is that this was once a money sack for the brief fees of advocates. According to some people, it was divided into two segments, one for gold coins and the other one for silver coins. So the theory is that since advocates were not openly paid for their work, clients made a payment into their counsel's pockets, literally behind their backs, to preserve the dignity. So the whole idea was that if an advocate could not see how much they were being paid, the quality of their advocacy in court could not be compromised. So the reason that I'm telling this to you today is everybody has, like I said, everybody has the right to be before court. And it is our responsibility as legal practitioners to do our very best in court and to bring each client's case before court as properly and as best as you can. It is not our responsibility to become involved in the drama of your client. I do a lot of family law, so it can become very, very intricate and very interesting drama. However, that is not my purpose at the end of the day. My purpose is to give the best case of my client, doesn't matter who my client is, and to give that case to the court to the best of my abilities. And that is why we have this court-craft webinar today, to teach all of us as to how we can do this and to be impartial and to bring the best out of each and every one of us. So I hope you guys enjoy it. And please, if you have any questions, please leave them below in the Q&A box and let us know. You guys are more than welcome to also chat to us afterwards. Enjoy this this webinar, and thank you, everybody.
Thank you for that, Hilda. That was truly, truly inspiring and very, very informational as well. I learned something new there today about the robe. And with that, and without wasting any time, I would like to hand over to Advocate Aisha Tiry. She is going to be covering fundamentals with insights. Advocate Tiry, over to you.
Igama lamakhosikazi malibongwe. Good morning.
Malibongwe.
Good morning. And I think what's apposite for this morning, because we're celebrating Women's Day, is watenta bafazi watent Mbokodo. So thank you so much to our opening panelists for highlighting this auspicious occasion. And in order to actualize human rights and to advance the rule of law, we've all come together as the South African Black Women in Law and the Johannesburg Attorneys Association to share the little bit of knowledge we have through experience and insights with you in order to advance the rule of law and to actualize Section 34 of our Constitution, which is access to courts. So my task this morning is really to speak to us as legal practitioners. So this presentation is designed and curated for candidate attorneys and for attorneys under 3 years in practice. Others who are attending are most welcome, but our focus really, in terms of how we've designed and curated this discourse, is to speak to candidate attorneys and junior attorneys under 3 years. This will become relevant in due course. Why? And what I want to start off with is really that I will speak to our environment. So let me give you the frame of my chat this morning. So I will address us first and through our environment, the environment all of us are in here today. And then I will speak to legal practitioners and focus on us in that environment. Thereafter, I will zone in on section 34, which is the client's right. Once we've interrogated section 34, I will then endeavor to share insights from my experience, given that I have about 2 decades in litigation practice. And I will close, as we all do, with the words of the Constitutional Court in S versus S, the 2019 Constitutional Court decision. I close with the Constitutional Court words because once we leave this occasion, we will be reminded that the rule of law applies. So as much as we are in this particular environment, the rule of law, what the court says, is binding upon us. And then that will be my discourse. And that's not the end of it, because we will then enjoy Advocate Naidoo's application of the fundamentals in the sphere of family law and bail applications. And then there's more to come, because the JAA chairperson will also be spoiling us with some insights from her. And of course, we've got our president that is waving the tapestry of this entire discourse and ensuring that all the pieces of the puzzle are beautifully entwined. So let's begin with my initial segment, which is our environment. So if I speak to you about our environment, it's good to be aware that today we are in an educational environment. So an educational environment, immediately what comes to mind is section 16 of the Constitution. So section 16 speaks to freedom of expression. And what is very important about freedom of expression for us today is that freedom of expression also includes academic freedom. So really what we're doing today is we're stretching thought. We are in an academic environment which we will be discussing practice, but we really have such a luxury because we are permitted to interrogate. We are permitted to think about everything, and we are allowed to challenge and to refine. So freedom of expression, why was it constitutionalized? It's an entrenched human right. Is it constitutionalized simply for democracy? It's not only for democracy. Freedom of expression is constitutionalized to foster human development. Now, this is so important because freedom of expression, if you look at lawyers, what do I do as an advocate? I'm touching my throat because it's the throat chakra, you know, to express yourself. So as an advocate, my whole role is really, I speak on behalf of others. So freedom of expression to me is also one of my favorite human rights. I'm quite expressive. And as we all know, there are always limitations in terms of section 36. So if you're speaking to your nephews and nieces, it's always good to do a little bit of an experiment, and you let them stand apart and let them swing their arms. And when they move towards each other as they're swinging their arms, this is where the limitation of your rights arise, because their rights are clashing with someone else's. So it's very important. It's a fun game to have if you have nephews, nieces, or children. Let them stand and swing their arms and tell them this is your rights. And as you move closer and they clash, that's the limitation of section 36. So it's a lovely exercise. I mean, the law is so fascinating, and education is truly fun. And for us to be in this environment with you today, and for you to be here today, it's such a privilege because we're speaking about something that is so critical. It's something that we love, and also in an educational environment, which is a truly luxurious environment. So as I said, we have freedom of expression. It includes academic freedom, and it is also limited. So what is the other human right that is really dominant in our discourse today throughout. If we were in a physical environment, I'd be asking you to raise your hands. Perhaps you can post it in the chat. And if you know what other human right is dominant in an educational environment, type it into the chat. You are most welcome. That human right is Section 29, the right to education. So when you're in an educational environment, it is an entrenched human right. It is Section 29. Now, this right has the basic right to basic education and the right to further education. So I think it would be hard pressed for us to argue that we are in the basic education environment. It is more plausible, given that we are already, if you're a candidate attorney and a junior attorney, already have a tertiary qualification. So we would then be in the right to further education. So throughout our discourse, these are our human rights as participants that we are actualizing. So it's good to bear this in mind, because it also indicates the parameters of our discourse. It indicates when we have freedom of expression, including academic freedom, that we are here really to ideate, we are here to grow, we are here to foster human development. And part of that understanding of fostering human development, it's okay to make mistakes, because when we express ourselves, and if there's an error in an environment, there can be correction built into that, because human beings, of course, as we are growing, that's growth, trial and error. So if anybody suppresses your expression, it is so ominous, it is so unacceptable, because they are oppressing your human development. But we also need to bear in mind that when we express ourselves, we will be corrected. Perhaps the correction comes through a court judgment and you have to pay damages because there was a delict and you defamed someone. So that is teaching us as a society that there are limitations to that particular expression. And the rule of law will mean that you are bound, and we are now fostering your human development because we are teaching society through judgments what the limitations are. So as much as I laud freedom of expression, we all have other human rights. Dignity is always paramount, the heart. So all these rights come into play. So now that we understand our environment, I think it is perhaps, because perhaps you're seeing my face all the time. Let me see if I can show you a picture or two. So when we look at, okay, so this picture that you are seeing is going to be essentially be what I expressed to you. I will be sharing with you Section 16 and 29, which we've now covered. As I said, this is the second element of my discourse, which will be Section 3.4. Later on, we will talk about my insights, and I will close with this. So this is really essentially what you will hear from me today. And part of that will be, this is the second element. So let me speak to Section 25, because I said to you that I would then deal with us as legal practitioners. So let's look at what Section 25 says. So Section 25 will speak to who we are as legal practitioners, but it's always good prior to that to just enjoy and remember, even though we are lauding human rights and we are celebrating women, to always remember the father of Black consciousness, and he is critical in an educational environment. So if you look at this beautiful picture, we are soaring. Here's this little story of the elephant. And what I will do, just stop screen share so you can look at me, is just highlight what I believe. And what I share with you, you must interrogate. Anything in an educational environment, you interrogate, you take that thought and you decide whether you entrench it and you move forward and you build on it, or whether you accept it and disregard it. Now, why did I raise the father of Black consciousness? The father of Black consciousness is Steve Biko. So what did he say? He said that the greatest oppression, what is the greatest oppression? It is his words are so fundamental, because it says that if anyone can type it in, this would be a fantastic opportunity to have words from the floor, because we should be knowing that the greatest oppressor is the greatest oppression is the greatest is the oppression of the mind. So I think I see that there are comments coming in. So we are all well aware of what Tata Steve Biko has said, that the greatest oppression is the oppression of the mind. So the mind, the weapon, the greatest weapon of the oppressor, those are the words. I was hoping that it would be typed in, and I think it came to the fore. Many are very aware of it now. So the greatest weapon of the oppressor is the mind of the oppressed. Now, those are not my words. Those are the words of Tata Steve Biko, and he's the father of Black consciousness. Now, just think about that a little bit. So if you look at oppression, systemically, what do we have? Systemically, we are fighting barriers to entry for women, for Blacks, and for those that are marginalized. And it's not, there are many. I mean, I don't speak enough for those that are physically challenged or otherwise enabled, but there are many that are not built into the system. So the system sees us as other and outsiders. So our fight is really to be in spaces that allow us to actualize to our highest self, so that we can foster human development with our freedom of expression, so that when we make those mistakes, we are not annihilated to the extent that we are ousted and can never move forward. We want a system that when we err, when we exercise our expression, when we are trying to grow, that built into that system, it allows us to learn from our mistakes and be better and actualize. So the problem that we currently have for Blacks and women is systemic oppression. So when you think of any environment, and we're in an educational environment, so I like us to always remember that also in an educational environment, because you bring your consciousness into education. Because why did I show you the story when I represented the picture? Let me take it back. Oh, I want to show you the story. This is a little elephant, a calf, and the mother elephant. So why am I showing you this? Because, there we go. So the reason I highlighted that is because I have crystallized a little story of the elephant. So I want to take this opportunity because I've been invited to address you and I have the platform. So I thought perhaps, like I showed you what you can share with your nieces and nephews, the way that you, the arms on the rights and the limitations. So take that forward. So perhaps you'd also like to teach and share the story of the elephant. My alumni, many of them will know the story of the elephant because I've addressed them on many occasions and they have heard the story of the elephant. So let me tell you about the story of the elephant. And this is very important in an educational environment. We are human beings, but sometimes it's good to use illustrations. So I'm demonstrating the concept. How do we train, and as humans, how do we control elephants? We don't take a wild elephant and that's huge and mammoth and all grown and start teaching that elephant on not walking certain places. We don't do that. If we want to have a circus or if we want to tame an elephant, we take them when they are calves. So we take the little ones because they are still able to be developed and guided and molded. So we take the calf, and that calf, what we do is we decide that we don't want this calf to be running wildly. We have certain criteria. We know it has to be calm, it has to bow when we hit it with a stick, or it has to do this if we move the stick that way. So what do? We tame them. So we take the calf and then we tie that calf up and we teach it when it's young that you only can walk 10 paces forward because that's the length of the rope. And then throughout its life, when this elephant is now mammoth, if you've seen an African elephant, I've had the privilege of being on the back of an Asian elephant in Thailand, and then I think also in India. And then I'm in Africa, so I have also seen what an African elephant looks like. African elephants are mammoth relative to Asian elephants. That's just a little bit of insight. But if you see a grown elephant, that grown elephant can yank that rope. It can destroy the cars before it. It is powerful. It is one, if you're in the Kruger's National Park, I mean, you know, it is one of the most dangerous animals. You do not want to set it off. You need to be careful because of the power of that mammoth elephant. But yet we are able to control that elephant. So the story really is that when you are young and you are developing, and this is not necessarily attributable to age. If I am now starting as, if this virus has interested me and I now want to study, become a virologist, and I'm young in that sphere. My mind is vulnerable because I'm now dependent on those that are a little bit more experienced. So when we are starting out and we are learning, we have an element of vulnerability because we accept educators, we accept teachers, and they have such a responsibility because if we limit you in your thinking, then we won't progress as a nation. We won't progress as a society. So why I've brought this element in is because we want to be, as the JAA and SABWiL, we want to be responsible educators. So to be a responsible educator, I am sharing with you the story of the elephant. We are highlighting section 29 and section 16 of the Constitution. And we also have birds on our presentation. And we have also Tata Steve Biko. So we want to be responsible. We want you to soar. And we want all of us to reach the highest that we can possibly, and we want to progress as legal practitioners. We want to progress as lawyers, and we want to advance the rule of law. Now, this is how I tie this element up. I believe that what I know and what I have gained with 20 years in litigation, I want you to use that. And I would like you to be better, because that's progress. If you only achieve what we have achieved, what the luminaries at the Johannesburg Society, Johannesburg Attorneys Association, or the SABWiL have achieved, if you only achieve the highest that we have achieved, then we have not succeeded today. We are aiming for you to surpass what we have achieved, because you have decades ahead of you. You have possibly 40, 50 years of practice ahead of you. You have definitely so much more time left, because my 20 years is now behind me. And I would like to discern from that. So you can use that to build and to surpass what we have achieved. And if you do that, then we progress as a nation. Then we progress and are advancing the rule of law. We are not maintaining the rule of law. We are advancing the rule of law, because we will be better tomorrow than we are today. So that's really what we want to, what we are aiming to achieve. It is our attempt at advancing a legacy, so that the rule of law is and human rights are lauded, and that so that is why what you are here today, what you are hearing today, is our submissions. It is not dictatorship. We are submitting into this environment that is luxurious, this educative environment, this environment of academic freedom, where there's freedom of expression. We are throwing into this think tank our thoughts, our experiences, and we invite you, taking into account the greatest weapon of the oppressor is the mind of the oppressed, taking into account the story of the elephant, taking into account human rights that have been entrenched because people have fought for those human rights. Our ancestors, our predecessors, our activists, they have shed blood, they have died so that we have those rights entrenched that we are lauding here today. So you need to play your role in terms of Vuk'uzenzele, stand up and do it for yourself. In terms of Ubuntu, 1 + 1 = 11. I am because you are. So taking all that thinking into account, the recipients of this discourse, and us too, all of us, we are all in a think tank today. We have that shared responsibility to interrogate whatever is in this think tank, to look at it. And why is this so important for a legal practitioner? This is even more important because we're legal practitioners, because it develops critical thinking. So one of the critical elements of every legal practitioner, something you always need to develop throughout any educational environment, is critical thinking. Critical thinking is really the heartbeat of your submissions, because I don't go to court. Advocate Naidoo doesn't go to court. Attorney Eksteen doesn't go to court saying, well, I just woke up this morning and this is how I feel about it. And I think this today. And we critically assess the brief and then we present the submissions. So submissions don't arise from clouds. That submission to a judge is critically assessed. So it was deliberate that we discussed this environment that we are in, that we laud human rights that we are articulating, the Section 29, the Section 16, including academic freedom. We are aware there are limitations in terms of Section 36. And all of this is essentially to highlight something that's fundamental to a legal practitioner. It is to think critically. So critically doesn't mean to complain. It means to look at things from various angles and then to interrogate what applies in which situation. So I may now have these submissions that I've presented on the story of the elephant, but if I head to court and I present this, that is not the appropriate forum. That is not relevant to the brief, but it is applicable in this environment. So there is critical thinking that has been applied in the presentation today. So whatever you do as a legal practitioner, a candidate attorney, and a lawyer, if you are in practice, critical thinking is fundamental. Any thought that is presented by anybody, your opponent, your client, immediately, that thought must be held in abeyance. So it's like that thought is in a cloud of its own. And you need to interrogate, and then you decide, where does that fit in? Is this now probable? Is this its gravity? I accept it, so it's common cause. Or is this so speculative that it's hot air that it can float around and I don't really, I let it pass. So what I'm saying to you is, when you are applying your legal knowledge as a lawyer, when you are exercising and practicing, you are throughout, whatever you do, when you're drafting, anything that you do, you are a critical thinker. So that, I think, would close this. It would close my submissions on this particular screen. And I'd like we want to progress as a nation. So if you find value in the story of the elephant, share it. If you find value in Tata Mbokodo's words, share it. So my next segment really now, and this has opened up us as legal practitioners. So I will want to address us as legal practitioners. And I think my submission to you is that Section 25 is truly critical for legal practitioners. So, and when I say legal practitioners, I include those that are aspiring and candidates, but I may not mention aspiring and candidates all the time, because I see you already as heading on the road, because you're here on a Saturday, a long weekend. So I applaud you for being here. And I think that, in my view, we are clearly on the journey. So legal practitioners, include yourself, aspiring. Section 25. So Section 25, really, if you are in court-craft essentials, if you are appearing, I would submit that you need to know what Section 25 of the Legal Practice Act says. And I would submit, when you head to court, you should have a file, or if it's electronic or a hard copy, but you should have Section 25 readily accessible. You should have the Legal Practice Act Code of Conduct, Part 6, applicable. It's very applicable. You should have it readily accessible. So let's talk files, because that's old school, but you understand, however it can be filed, it should really be filed in your head. But if it's not filed in your head, the next best space is a physical file. So you'd have a printout of Section 25, and you'd have the Part 6 of the Code of Conduct. I think if you are starting your own practice, I would include Section 34. It's a little bit more advanced. But once you're practicing, then Section 34 of the Legal Practice Act is quite critical. So let me take us to that. Screen share. Section 25. So Thank you to the Legal Practice Council for furnishing us for our discourse today with the exact number of candidate legal practitioners that we have nationally. It's 6,201. In South Africa, candidate attorneys are 6,201. This is not all candidate legal practitioners. It does not include the pupil advocates. So this is only candidate attorneys. Interestingly enough, if you look at the legal practitioners under 3 years, it's 6,101. So nationally under 3 years. So if you look at that, I mean, there's a clear attrition rate because under 3 years, it's the exact same or it's similar to what we have in 1 year for candidate attorneys. So a lot of candidate attorneys are not proceeding beyond their articles. They are either not in practice, because if they were, this number would have been so much higher. So this is just interesting for us to know. So why have I said section 25? Why is it my submission that section 25 is so important? Because I wouldn't want any of us to be embarrassed and head to court. Our principal or the senior attorney in the firm, I said, oh, just have a look, is this matter on the roll? If it should have been removed, it mustn't be struck. So I've seen it on many occasions that a matter is being struck. A bright-eyed candidate attorney will stand up and say, that matter was removed. Can that candidate attorney in high court stand up and speak to a judge and say that the matter was removed? Is a candidate attorney allowed to do that from the public gallery? I understand the pressure of the firm. I understand that we have accountability to report back to the seniors. I understand that you're trying to save the client. And I understand that you are truly looking out for the best interests of your client, and you're daring the world and you're daring whatever may come by brazenly standing up in open court, in the High Court, to protect the interests of your client and to report back to your principal or the senior attorney that you tried. Now, what does section 25 say? So we want to protect all of us. We are legal practitioners. We cannot speak for a client unless we are in compliance with the legislation. So when a client has a right in court, please bear in mind, it's not our right. It's access to court is not my right, unless I am the client. But access to court is the client's right. So when does a candidate attorney, a legal practitioner, when do we have the right to stand up in open court and address a judge or a magistrate on behalf of a client? Section 25 will answer this question. If you study section 25, an advocate that is duly admitted and enrolled has the right to practice in all the courts in South Africa. So I can speak to the judge. I am authorized statutorily unless there are impediments. Now let's look at an attorney. So if this is your first year, if this is your second year, if you are one of those 6,000 that I showed you on the earlier screen, can you as an attorney appear in the High Court, the Constitutional Court, the Supreme Court of Appeal? What does section 25 say? So you need to study that, because sometimes I shouldn't be giving you the answers that are clear. But to ease our discourse, perhaps I can help the candidate attorney, and then those attorneys will derive the answer because I've highlighted what candidate attorneys can do. So candidate attorneys can appear in court on behalf of and instead of the person under whom they are supervised. So you call that person a principal, I understand. I was never an attorney. I worked in attorney firms as a law student, three attorney firms, 2 in Port Elizabeth, and I did vacation work in an attorney firm here in Sandton. So my experience as an attorney is not in an attorney firm is not formal. It is as a law student. But I'm very, very appreciative of those attorneys that allowed me to, as a law student, they opened their door to me. They allowed me to file documents, answer the phone, they explained things to me. I was even allowed to consult with an estate agent, and I was a law student. So, I mean, this was all amazing because those attorneys had decades of experience that allowed me into their practice so that I could learn from the environment. So it is good for you to be aware that I don't have formal training as an attorney so that you understand my perspective. I am looking at the legislation. And if you want deeper insight, there are senior attorneys at the Johannesburg Attorneys Association. They can readily address you on any queries that you think I may fall short on. I am doing my best. I can speak authoritatively, I believe, on Section 25, and I do believe that the section states that a candidate attorney can only appear in all courts, but not the High Court. So what does that say? That candidate attorney in the High Court that jumped up to protect the matter did not have the right to address the judge. A candidate attorney cannot appear in the High Court, the Supreme Court of Appeal, and Constitutional Court. Now, what's special about Section 25? Section 25 says that you appear instead of and on behalf of your principal as a candidate attorney. I found this very, very remarkable because, remember, my training is an advocate. So I looked and I thought, okay, where's this for a pupil advocate? Does a pupil advocate have the same right? That section doesn't afford a pupil advocate that is not admitted and duly enrolled to appear. So if an advocate that is training, you have to be admitted and duly enrolled. Read the section. So you have special provisions because you're not yet a legal practitioner. We as advocates must be in compliance with Section 25. And then, yes, the other bars may say that we will, have certain training for you, rules that regulate, and they subscribe to those rules voluntarily. So they would then be appearing with certain prescripts which they voluntarily adhere to. But I'm speaking to the statute because voluntary associations can have their own limitations. They can say, while we're training you, don't do this until perhaps 6 months have elapsed or until we've certified. But technically, in terms of the legislation, you are very, very special as candidate attorneys. And it's quite remarkable. But what does that do? When I interrogated that section, I thought, wow, this is serious onerous obligations on those principles. When I read that section, a candidate attorney, you read the section, appears instead of and on behalf of the person under whom they are supervised. So that means while you are appearing, there is a nexus, there's a link. So a magistrate in those magistrates courts that you're appearing or forums, if your conduct doesn't pass muster, there is a link directly to your principal. And I would, if I was a magistrate, I would possibly not only chastise the candidate attorney, I would call in the principal because why is this conduct not up to standard? Have you not monitored the conduct? Are you not aware of your candidate attorney's submissions? Is this on behalf of you and instead of you? So all I am saying is that it is important for a candidate attorney to understand this because you do not have that freedom to simply make those submissions outside of the parameters of your principal relationship, because you are really linked so inextricably in terms of the legislation to the person under whom you are supervised. So that is a lot of responsibility. So for a pupil advocate, that provision isn't really there statutorily. It may be in voluntary associations. That's a different angle. I'm not addressing you on voluntary associations. I'm addressing on Section 25. I don't know if there's amendments coming. I'm not addressing you on what is best for the legal profession as a whole. I haven't interrogated it on that level. We are here simply for appearances today, for us to know when we can appear and we cannot appear. So I would submit that the candidate attorney, if you're unsure, you don't know what needs to happen, take guidance from your principal. And I will definitely say that Part 6 of the Legal Practice Act Code of Conduct is applicable to candidate attorneys and legal practitioners. So that you should heed. So immediately when there is a case that you're working on, see if any of those provisions in the Code of Conduct, which is binding on us all, applies. If you don't understand it, or if you do understand it, or if you want to explore it more deeply, discuss it with your principal, discuss it with other seniors in your firm. And if after all of that, there is uncertainty on how your case, if you're a legal practitioner or candidate, my level, whatever level, any legal practitioner, if you're unsure, what is the avenue open to us? The avenue open to us is to seek a ruling from the Legal Practice Council. They have provincial divisions. So Gauteng would have their own provincial division. So then you crystallize what you need clarity on, and then you request a ruling, meaning you're asking for guidance because you don't want to fall foul of the conduct rules. So there is always recourse. And of course, you look at the case law, you discuss if it's in a situation that nobody knows and it's not clear, and you want to do the right thing, and you'd rather, once you have that clarification, the ruling, then truly you are guided, because if you make submissions based on that, then you've been guided by your profession. So how can you really be in the murky water? So you are protecting yourself. So I think that is quite remarkable. I look at it from a different perspective because, you know, I've mentored pupil advocates. I've been a pupil advocate. I am an advocate. So I was quite excited that there was something very different there happening in the training, in the legislation. So I don't know. I haven't interrogated what's best. That's a different assignment, because it's always never what's best for us. It's what's best for the client. And in this particular situation, the candidate attorney is not yet a legal practitioner. Now, so it is to be in the supervision and guided while you're appearing should be better, because your submissions are clearly under the supervision of someone that is a legal practitioner. And yet you have the right of appearance in the magistrate's court and anywhere else other than the High Court, the Supreme Court of Appeal, and the Constitutional Court. What that does do, it says as a candidate attorney, you don't have that independence of a legal practitioner because you are annexed. So you also don't have that clear objectivity, because you have to be linked to your principle. And that's fine. I mean, that's training. You're not a legal practitioner, so be aware of that. And seek guidance, because your submissions in those courts are linked to your principle. They really are. And you reflect your principle more than anyone else. So when I stand up in open court, my submissions are independent. They are impartial. I am not annexed to anyone. And the advocates that appear in terms of Section 25. We don't have that luxury. I don't know if it's a luxury. I don't know. I haven't interrogated the merit. But when an advocate stands up in the High Court, and in any court, we are duly enrolled, and we are independent, and we must be impartial. So we make those submissions on behalf of another person. What is very important to know is that the regional court, can any candidate attorney appear in the regional court? If you interrogate Section 25, the answer lies there. Section 25 says a candidate attorney that has completed 1 year of practical legal training, or an advocate that has been in, or who was an advocate in practice with 1 year experience, then you qualify to make submissions and appear in a regional court. So that's also very important to know. So there's a distinction. So it's based on your experience of PLT, or if you have 1 year experience as an advocate. So I think that's really, really fundamental, because if this candidate attorney that I observed standing up was aware of Section 25, then this wouldn't have happened. So perhaps this is fundamental. I do believe this is fundamental to your training. So any candidate attorney, this is not something that should just be in a file. The file must be up here. So you should know this. This is, I would fail you if you came for an oral and an exam and I asked you questions about this and you did not answer adequately, you would not pass my examination. That's just how serious I believe this is. So these are my submissions. I'm not a trained educator. I am an advocate. I have no qualifications on how to educate you, but I have educated pupil advocates. I have mentored them. I am working in an educational environment, and I can share with you that if you appeared and I was a magistrate and your conduct was not up to standard, I would possibly call in your principal, because to chastise you on your own, it's not really, you're under guidance. There's someone else that's accountable for your conduct. So it is, but that's me. So others may not do what I do. So I think Section 25 is really, really vital. What I've omitted to share with you, which is interesting as well, is if you're under 3 years as an attorney, then you also don't have High Court rights of appearance, Constitutional Court and Supreme Court appeal rights of appearance. I think this culminated because, it really is protective in nature. It's protecting the legal practitioners really, and the clients possibly. But it is, but there is an exception to that. So the exception is that you can appear in the High Courts, Constitutional Court, Supreme Court of Appeal, if you complete an accredited course. That the LPC has accredited certain training. So there's a course that trains you on appearances, and that is accredited. And then the registrar that furnishes you with your certificate of appearance as an attorney will consider that, because this is all mentioned in the statute. So you need to have that certificate after three years. You apply for your certificate, and it should be, as long as you meet the Section 25 criteria, be furnished to you. So an attorney can appear in the High Courts, Constitutional Court and Supreme Court of Appeals like an advocate after the 3 years have transpired and they meet the Section 25 requirements. So I would say to you, if you want to know what the gospel is of our rights of appearance, study Section 25 of the Legal Practice Act. I think now that I've covered section 25 to the extent that I have intended. The rest is really up to you to interrogate for your particular practical circumstances. And I would then deal with the appearances. Let's deal with the prior to appearances. Let me cover section 34. That's fine. Let's deal with section 34 because section 34 is not yet section 34 of the Constitution. I still need to reach that segment. I want to deal with section 34 of the Legal Practice Act. So the way I always remember it, and maybe you'll remember it this way too, is that section 34 of the Legal Practice Act deals with forms of practice, the forms of legal practice. And section 34 of the Constitution deals with access to courts. So there are different sections in different documents, but right now we are speaking to section 34 of the Legal Practice Act, and that deals with forms of practice. Now this might be a bit more than you need to know for now, but it's where you're headed. So it is good to be aware of this. So section 34 really tells us how attorneys and advocates are allowed to form practices. So as an advocate, I am allowed in terms of the statute, in terms of legislation, to practice independently. I am not allowed to have a partnership with Advocate Naidoo. I'm not allowed to have a partnership with Attorney Eksteen. That's the legislation. Section 34 says, Advocate Tiry, you are a sole practitioner. It is to preserve my independence. It is to preserve my objectivity, my impartiality, structurally. Then there's deeper insight to it, but for application, we simply apply the rule of law. That's what the law says. So you cannot find me in a partnership as an advocate. Attorneys are allowed to practice in partnership. Attorneys are allowed to practice in partnership. And this is a partnership with other attorneys. So they cannot be in partnership with anyone else other than attorneys. They can practice on their own. And this is really very important. So I've highlighted the forms of practice and read and study section 34. But why do I say this is so important? Because if you look at the other countries, if you look at what happened in the Arizona Supreme Court, they're the first state in August 2020, they permitted variations. So they are allowing attorneys and non-lawyers, lawyers and non-lawyers to practice together and to form an entity. So, and they are allowing fee sharing between lawyers and non-lawyers. So there are three segments. A non-lawyer can have an economic interest in the matter, in the firm. A non-lawyer and a lawyer can fee share. And then they are crystallizing something that is akin to, it is akin to a legal paraprofessional, so, sort of like a nurse with a limited license to do certain things. So it is good to see, and this is only applicable, it is effective from January 2021. If you look at the UK Legal Services Act of 2007, they have firms that are alternative business ABS, alternative business structures, and they can list. So they can be a public company and draw capital externally. So section 34 subsection 9 of the Legal Practice Act says that the Legal Practice Council will deliberate on our forms of practice and in a certain time frame can make submissions to the minister on multidisciplinary practices variations. If I was very interested in this, that we you are invited to collaborate and make submissions. If you're passionate about it, it's your future in 10 to 20 years time, if you want to craft a different form of practice, all for the advantage of the client. Because the Arizona courts, when they determined their changes, they looked at innovation and what was best for access to court and affordability for the client. And the thinking was that lawyers are not the only ones that advance the rule of law for the client, that there are many non-lawyers that play a role, and that this should be regulated. And Utah has a bit of a sandbox that's still being investigated. So what I'm saying to those who have decades left in this profession is that the profession you're practicing in 10, 20, say 30 years may not be the profession I practiced in. So, but who will hold the final say? The final say will always be the Constitutional Court if there's challenges. The legislation may be there, but perhaps some of our peers as legal practitioners challenge forms, and the access to court section 34 is really what will be critical. Is this in the client's best interest? It's the client's right. So what is the best forms of legal practice for the client? The president has, Cleopatra has indicated that Advocate Narisha may still have a segment. I was under the impression that I had flexibility in my time so I could address what needed to be addressed. President, would you like Advocate Narisha to speak to the application and then I continue thereafter, or would you like me to continue because of the note that I received from you?
I would just like to find out from Advocate Narisha how long she will need for her presentation, then we can take it from there. Advocate Narisha? More or less, not necessarily specifically how long, but just more or less how long? 20, 30 minutes?
President, weren't we really going to have flexibility and I was allowed to proceed, or would you like me to deal with the appearance section? Because I have a short segment on appearances. And then after I deal with appearances, we allow Advocate Naidoo the application, and then I can continue with the rest if that satisfies you. I truly believed I had the flexibility.
Okay, not a problem.
Advocate Naidoo, what would you like? How would you like us to present? Would you like me to complete the appearances section and then you present, and then I will continue thereafter? Okay.
She's happy with that.
I think so from the nod. Thank you very much, President,
Fantastic.
for showing us
Thank
direction. It will take us to the slide because I know exactly what I want to complete. So all I would want to impress, when we look at the screen that I'm sharing, these elements, professional etiquette, conflict, public comment, interviews, cross-disclosures, effective court processes, this is extracted from Part 6 of the Legal Practice Act Code of Conduct. There are certain categories in that. Now, I will direct you to study the Legal Practice Act Part 6. This is really obligatory upon us. But prior to that, and prior to Advocate Naidoo addressing us on the application of the fundamentals, let me share with you the fundamentals that for court appearances. So I have divided that in my mind into two categories. The appearance category and before the appearance. So if I was drawing a note, it would be, I'd write the word appearance and I'd have an arrow to the left before and then the actual appearance. So let's talk about before appearance. So before you appear in court, what is really critical? Everything is mental. So I think you need to prepare your mind. And the way you prepare your mind is to prepare on process and substance. So if you prepare on process, what does that mean? It means you know the court that you are headed into. It means that you know the practice directives of that court and the rules of that court. Is it the magistrates' court rules? Is it a tribunal, a forum? Is it the uniform rules of courts? So you need to know the process. In the high courts, we have different divisions. Different divisions have different practice directives. So practice directives, it's vital. You cannot appear in a court and not be aware of what the practice directive is. It is obligatory on us as legal practitioners to be aware. What I do as well, if I'm appearing in a division I haven't really appeared in, and it's not mine, if it's in Durban or if it's elsewhere, I will phone a colleague. Like I would phone Advocate Tono, I would phone, if it's in Pretoria, I'll phone Advocate Hassam SC, Soraya Hassam. I'd ask her, is anything different? This is what we do in our division. Is there something that's novel there? But what's good to do is always to touch base with someone that's in that court daily, we are not in that court daily. Or if it's your first appearances in those particular courts, if you've never appeared in the High Court before and you're heading into a trial court, take the liberty of sitting in that court. If it's non-pandemic environments and you were allowed, you take the liberty of observing what happens. Head to the court. In other words, do a practice run. So see what's happening so that you are confident and comfortable. So preparation is mental and physical. Then the next component of preparation is substance. You cannot appear in court if you have not prepared on the material. You need to present and you need to be aware of the cause of action. You need to be aware of what's common cause, what is the issues in dispute, because the judge is not interested in the frills. The magistrate, the judge wants to know what their job is. Their job is to judge. Their job is not to give you legal advice, by the way. Many people appear and they want advice, and a judge and magistrate, rightly so, should say, my job is not to advise you, I'm here to judge. So you need to head to court and know what the judge or magistrate needs to judge upon. And you need to know how you will advance your client's case and what you do. So this is all part of the preparation. It really is fundamental. Preparation. When I was a pupil advocate, I was told in my training that court is a place for execution and preparation is for chambers. I believe that. So I would tell that to you as well. Court is for execution. And yes, things happen. So you need flexibility because maybe the witness that you planned that should have been there hasn't arrived. And so you need to be able to think on your feet, but you need to prepare. So you need your plan, and then you need to have that flexibility on what happens if something goes south and what do I do in that situation. So it is always good to prepare. Your best preparation leads to your confidence. Because if you're ill-prepared, your presentation and execution will be atrocious. It is unacceptable. You cannot do justice to the client's rights. So without preparation, do not continue the brief, release the brief, do whatever you need to do. But if you cannot prepare adequately, you need to surrender. I don't think that you can do justice to the client's rights without properly preparing. And also, what comes into play is clients need to come to us timeously. So if the client is coming to an attorney, they need to come to the attorney timeously so the attorney can actually contribute substantially to the matter. If the attorney is heading to an advocate, approach us timeously so we can really do justice to our brief. It is difficult. There's only so much we can do if it's 11 o'clock at night and the appearance is the following day. So preparation is truly, it's the be all and end all. And don't assume that, it's a simple matter. There's no such thing, because if it's a simple matter, an attorney wouldn't receive the brief and the advocate won't receive the brief. The client will do it themselves. So if it's so simple, it's a really bad thinking, because a judge, you can't anticipate. In my view, every single matter is an important matter. If it's an unopposed motion, if it's a magistrate's court matter, every single matter is an important matter, because it's a matter for the client. It is so important to somebody. So until you can honor that importance, if you're going to look at it askance and think, oh gosh, I don't want to do this, it's beneath me, then please don't take that brief, because you need to bring the right mind frame into it. So that really is very critical. If you fail on the preparation, on substance, in your mind and on process, then I truly don't think you can continue adequately on the rest. The rest is really, to also be aware of the dress code. So different forums have different dress codes. So, and as an attorney or as an advocate, you have your own robes. And if you are attiring as an advocate, you'd have your robe, you'd have your bib in the High Court. We still don't robe in the Magistrates Court. And dark, what do we wear under the robes? It is really, I would say dark attire. Dark attire doesn't leave you in trouble. Black and clearly the correct color shirt, not a black shirt. You need to study what that forum finds acceptable. For the High Court, I would always wear black. If it's dark, it's near black. The reason why do we do that? We do that simply because we don't want to stand out with our personality. We want to make sure the client's case stands out. This is not about us. Today, the best we can do is possibly wear eyeliner and lipstick, but it's really about showcasing the client. And the way the courts want that, and we follow, we apply what the courts want, because we are not the ones that have made that law. We must adhere unless we want to challenge it and challenge it through the right forums. But it is really that, everybody is equal before the law. So we want to present our case in a fashion that is acceptable to the court. The court's protocol is such, so we comply with the court's protocol. And I haven't really had any issues with the robing and don't robe. Or I will talk about that at the appearance side. So I think if you have your mind prepared, you will also, when you garb your mind on the process and on the substance, part of that is respect. So whenever you are heading to appear, the fact that you're prepared is respect. The fact that you understand that this is an important matter to the client is respect. But it's so disrespectful to not prepare. So that respect notion, you carry forward throughout, right into your appearance. And if you have humility and you understand how important that matter is to the client, how important that matter is, it's calling for a judge or a magistrate to render a judgment. How can we not think that matter is important? I take issue with people that say, oh, these are not important, it's trite. If that needs a judgment, if it needs a magistrate, if it needs a court, if it needs a process, if it needs you as a legal practitioner, a candidate attorney, or an advocate, truly that matter must be respected. We must come to that brief with humility, and we must take it forward. And when we head to court, we don't head to court trying. I know that when we're young, we are trying to develop and establish our personalities, but that's really not critical. We as individuals matter very little. It's the client's right that is showcased. So the way you showcase the client's right is through proper presentation, your preparation. All of this is eventually so that you can take this case and present it in a way that is most favorable to your client. So what you're doing is, it's like an art picture. It's like a frame. So everything that you are doing when you are heading to your appearance is you are painting that picture, you are framing it, and you are presenting it to the judge or magistrate. Now, part of your preparation, your dress code, your respect, how collegial you are with everyone else, that's part of your case. It may not be exactly in your appearance, or it may be, but all of this is headed because you're drafting your papers, everything. It is for the client, it is for the appearance. So I would say that we also know devices, you know, as you're preparing, as I prepared for this presentation today, I muted my cell phones, I muted things that could make a noise. I closed doors so there were less interruptions. Now this is a bit more relaxed. So even if there was an accident and the phone rang, but in a court situation, that's obligatory. You need to head into the court. So that's why you're preparing. You know that if you're heading into court, your phone is off, or it is such that it does not trouble a judge, it does not distract. So those kind of devices. Now, the other thing is that before we appear, we also need to introduce ourselves. So if you're it's just common courtesy. It is ethical. So you don't simply appear and speak to a judge or magistrate. You introduce yourself before the appearance. So the judges have a chamber, and what you do is, for the High Court, and if you have an opposed matter, you would introduce yourself in the presence of your opponent. You'd wait for your opponent. Together, you would approach the judge's registrar. I was a judge's registrar in 1999, so I worked with judges. So advocates came to me to introduce themselves to my judge. Now, what I want to say to everyone, and this is very important, no one can approach a judge directly. You approach a judge through their registrar. Do not think that you can pick the phone up and phone the judge. You phone the judge's registrar. And later on, it will become very important when I share with you my insights, because this is to protect your client. It is to protect the judge. It is to protect the entire judicial system and the rule of law, because you don't want elements of bias to infiltrate. You don't want the case to start de novo because someone says that I had the one advocate had a long chat with the judge and this happened and that happened and they persuaded the judge. We just don't want that. So when you're headed to a judge, you head to introduce yourself to a judge. If your opponent is not available, then you tell the judge's registrar, I am here. I'm awaiting my opponent. At least the judge's registrar knows I'm there, time is asleep. If my opponent is 10 minutes late, they know I am there. It is not my fault. I am there. I would then say to you, the courtesy, pick up the phone your opponent, say, what's happening? I'm at the judge, because sometimes maybe they went to the wrong place. So what I'm saying is you are not opponents to the extent that you not help each other comply with the processes. So there's no vindictiveness. There's this, I mean, I've had wonderful opponents up those stairs in Johannesburg. I've got a heavy bag. They'll carry my bag for me. It's really fantastic. Not everybody, but I mean, it's a heavy bag. It's a lot of stairs. So, I mean, it costs them nothing to do that. So all I'm saying is you need not be that courtesy, because you live with each other. Legal practitioners, we are a small community. And also it opens doors up for conversations, because later, as you will hear, legal practitioners, you may want to have a discussion about condemnation. You may want to have a discussion about something, but it's not personal. So you have that strong collegiality. We are legal practitioners. We are all on the same side of advancing the rule of law. We may be in an adversarial situation, and we may be fighting about what the law is to be applied, but we are not fighting each other. So why I'm saying that is normally when we start out young, it's about proving ourselves. We want to prove I'm a good lawyer, but that's not it. That's not how this works. Dignity, decorum, that is how it works. So every single person, this shouting or this speaking in disrespectful fashions and demeaning, derogatory language, racist, sexist things, unacceptable. Don't do that. It's just, it does not advance your client's case. It will never advance you as a legal practitioner. But your client's case is a frame. You are framing this. You would even want your opponent to, in their mind, capitulate and think, oh my word, I've got a losing case. Because once your opponent starts buying that, they want to settle, they'll knock on your door and you'll see the overtures. I've had many matters that don't proceed because they settle. I've had matters that do proceed as well. So I have experience all around. But what I'm trying to say is, do not underestimate. The doors of settlement are always open. The doors of negotiation are always open. Once you start becoming vile, belligerent, obstructive, you close so much doors. So always just simply be dignified. If people are treating you with disrespect, then just don't tolerate, walk away. I don't get into catfights. It's possible, but I would just leave. And then you'll see. I mean, they probably had a bad moment. That person gets over it, they move on. So we're human. It's a highly stressed environment. So I think if you're in a litigation environment, it's an exceptionally stressed environment. Nothing else is important in that environment except the client's case. So don't underestimate the stress level. It is highly, highly stressed. When I am in litigation, I can tell you, I pump adrenaline, I pump testosterone, I am on high drugs. It's natural, but it is like an elevation of note. So what I do after I litigate, because I'm experienced, I actually take a walk. I have to process that. It has to run out of my system. So I process it. So I would say you need to know for your mental health, if you're litigating, you need to understand the level of stress. I'm experienced, so I know how to deal with that. I do yoga in the mornings. I eat healthy. But I can tell you, if I've been in court, it is not humanly possible for me not to move my body and walk. I need to get that adrenaline out because you pumped. It's just the nature of litigation. Litigation is highly stressed. My team, my attorneys, everybody that's with me in court, they experience, they understand. So sometimes we might have a clash in the team. It's fine. We let it flow because we all want one objective. It's like a soccer match. We all have to get that ball in that hole. So even if there's maybe a little bit of bumps and twigs here, we suppress it. We may deal with it afterwards, but not while the game is on, not while you are litigating. Because if that happens, the team will south, clients' rights all capitulate and everything collapses. So your team is also very, very important. I can't work with people that don't have a strong work ethic and that doesn't do their best. If that doesn't happen, then that preparation element, everything collapses. So I think the introductions, it is important. If you are heading to the magistrate's court, I would say introduce yourself to the magistrate. I would say do the same. Wait for your opponent. It may be a bit more relaxed, but I'm a high court practitioner, so I take that formality with because it just is protective of the individuals. It's protective because no one, there's a saying in Afrikaans, wat gebeur in die donker, kom uit in die lig. So it means what happens in the dark comes out in the light. So that's why I like my opponent with me, because it protects me too. It protects the judge. It protects the magistrate. I like that openness because then the opposition is there, nothing south. Now, the code of conduct rules will say, yes, in certain situations, if you have permission, you can do certain, there are exceptions to all the rules, but their reasoning for why they're there is really so that the fight never becomes ours. It always remains the client's fight. I don't want to fight about my opponent that I said this in chambers and that happened and this. But if we're there together, it can be all on the table and we can deal with it there. So I think there's something else that I've learned that may be relevant. If you have a medical issue, you know, if perhaps, you know, you have an eye pointing in one direction, or you have a stuttering issue, or it's your choice whether you want to speak to the judge privately with your opponent to say, look, my mouth dries when I present, and I've been advised by my doctor that it is better if I chew gum. It keeps this, it's not that I'm disrespectful. Is that permissible, magistrate or judge? It is, if you have explained that, you're not going to get a lashing in court. The judge won't, or magistrate won't think you're disrespectful. But I don't know what medical conditions are. I've heard that there are neuro conditions where people may look askance and then the court thinks you're not looking at them. So you need to, there are liberties. We are human, judges are human. They're not going to chastise you. But out of the respect and the courtesy, if you are chewing gum and you haven't told the magistrate it's because your mouth dries and it's the way you manage presentations, you're going to be chastised because it's not something we commonly do. You don't chew gum. And I think, you know, in the beginning when you're starting out, don't do things that are exceptional. I mean, just if you're drinking in the court, just drink water, you know. Don't come with some fancy shake, or try and first just blend in. Do what works for everybody and try and keep that pizzazz and your unique personality for your friendship circles, because truly what must be showcased is the court. So I think on the appearances, when you are appearing and you walk into court, when you walk into court, you should already be robed. So you should be already robed. You shouldn't be robing while the judge is calling your matter, walking from the front. That's just unacceptable. So your robing should already be there. What we do as counsel is when we walk into court, we do a little bit of a bow because we are accepting the decorum of the court. We are acknowledging that we are bound by the protocols of that court. And then if you're junior, you normally sit at the back. So the seniors sit in court in front. And then that really, you know, but now remember, be practical. Because if you have a soft voice and the judge is not going to hear you. So, I mean, if it's time for your case to be heard, then move up to the front and just stand behind the podium so that you can be heard. Because why waste the court's time? And the judge must say from the back, I can't hear you, come to the front. So you need to think that already through. And I mean, the other advocates or attorneys that are senior, they will know it's your turn. They're not going to shout you, or, I mean, you are doing what is helpful to the judge. So if you need to be heard, make sure that you stand in a position so that you can be heard, and you articulate so that you can be heard. Project, because really, why must we struggle to hear? Don't shout, don't shout. So I think that it is important also to know, I am exceptionally irritated when counsel stands up and there's two counsel or three counsels standing and only one is speaking. So when an advocate or an attorney that is appearing speaks, everyone else must be seated. So if I want to object, I will stand up and my opponent will look at me and say, I see Ms. Tiry wants to address you, my lord, and sits down, and then I will speak. And then after I'm finished, I sit down. So when I'm finished, sit down, unless the judge is still engaging with you. But this is how the flow works. Because if it's two people standing and one person's talking, who does the judge look at? So why is this all important? Because it's a huge court, or we are showing the judge the one standing is the one that the judge needs to pay attention to. The words of importance submissions are coming from the person standing. Yes, maybe it's a full court, but then those others will stand on the side and they are not cluttering where the audience would be, the address would be. And also, I was a judge's clerk, so my training is a little bit more like, you know, I'm a bit more pedantic than most. I don't like it when you address from the side. I would always say move to stand so that I have a bar, like I address from a podium. It may not be the actual podium itself, but I would be standing behind those bars. So I'm in the area where advocates can be addressed. Others do it. I mean, they would address from the side, but I was a judge's clerk. So my training is, judges are, you know, they notice these things because it is their court. The court belongs to the judge for that day. They are in control of that court. You control your case, but the judge controls the court. So they notice everything, and they notice if you are one of you take. They may not address it at that time because it's not that material, but you want to be in compliance with the protocols of the court. You want to already be seen by the judge to be an advocate that is prepared, an attorney that is prepared. When you make submissions, I know that when Advocate Naidoo, Advocate Tiry, Attorney Eksteen make submissions, I know that they have researched that. If I ask them for the authority, they will find it, they can provide it. So you are building your credibility, because the judge's job is easier if we do our work, because otherwise the judge will need to second guess us and check every single thing. The judge knows this. They know the law. So, but we need to help them and make it easy and say, this is the section, this is the act. So I think also in my training, be aware, there are times where you use the subjunctive, if I may, or whether you take, like, if I may, or I beg leave, but there are times that you don't. So you don't always need to be so differential. I was trained, he's late now, Judge Stegman. So he said, you know, this with counsel being so differential, if I may hand up the document, he said, just hand up the document. I hand up the document. So choose when you take that differential, if I may. But according to the late Judge Stegman in my training, he said, well, so you're right, I hand up the document. But don't be belligerent about it. But there's nothing wrong with saying, if I may. I would say, if I may, on certain things, if I may address the court, or if I may, or as it pleases the court. So as you start, you stand when it's your matter, and then you say, as your lordship pleases, as your ladyship pleases, or as the court pleases. So you have a choice, right? So why you start that way is because you're showing the court you will be the one that addresses the court. The court needs to look at you. Then you proceed, because remember, if you stand up and you immediately proceed with an essential point, the judge still needs to look at you. So maybe that first part is missed. So you are always showcasing your case. You are always placing your case in a frame. So when you stand up and say, as it pleases the court, it is your frame opening. Then you'd say, my lord, this is a summary judgment application, and then you proceed. So you don't stand up and say, this is the summary judgment. I would say, as it pleases the court, or as your ladyship pleases. I wouldn't go as the court pleases. I would go as your ladyship pleases, or as your lordship pleases. That's for the high court. I would say most things are so similar in terms of deference and in terms of respect for the court. In the magistrate's court, it's your worship. It's not my lord and my lady, it's your worship. And I don't like it when advocates from the bar say to the judges, your brother, your sister, this. It's not acceptable. The judges can say, my brother so-and-so, my sister so-and-so. It's not me as an advocate that says your brother, your sister. I will say, her ladyship, Miss Justice so-and-so, or his lordship, Miss Justice so-and-so, in case so-and-so. I'm not going to say your brother this, in case so-and-so. I don't think that's correct. I think the judge can use the word brother and sister, but the advocate uses the word her ladyship, or the magistrate, or so and so, or his worship, so and so. But I wouldn't. Those are particular to me. You will see many other advocates do that. I don't agree with that for myself, because I was a judge's clerk, so I'm quite. The other thing you don't. If you're not happy with what the judge is finding, you don't tell the judge you're going to appeal. My lord, it's fine. As your lordship pleases, the appeal will be ready. You just don't do that. I mean, it's so rude. It's so disrespectful. It's unacceptable. I would even think it's a form of misconduct in my view. But let's not go there. You don't tell a judge, I'm going to appeal before the judgment has even been rendered. How idiotic is that? That is simply, I mean, you need to read the judgment. You need to see, you need to consider, you need to take instructions. You can't. So it is done, but you don't do it. I would not submit that. That's not something I recommend one does. And if you lose, as it pleases the court, keep cordial, keep dignified, no throwing your toys, no throwing your pen, no, you know, that's, I think what is advisable to do, if you are everyone has different personalities. I have trained, you know, there was a stage in my life where I did the first year of Kung Fu, and I was around all these very young guys. And I think, you know, training exercise is a good thing. So if you find you're a boisterous individual with a lot of energy and you're going to throw your pen, perhaps go for a soccer run or go before the court, you know, get that energy out of your body so that you can be calm and collected when you appear in court. Because it's just energy, it just spills over. It's what we call yang, you know, that, and it's not going to advance your case. You need to make reasoned submissions. So everyone's personality is different, but I saw it when I worked with a young gentleman, when they were training. I mean, after that training, they were just like completely, it's just talk and cheese. It's like a different thing when you see what training does, physical exercise. So I would say, if you're in litigation, I can't see a way that you don't have some sort of physical exercise. You need to, because there's so much adrenaline and pumping. And we don't do drugs, you know, we don't do that easy notion. We are all, I mean, the only thing I would do is coffee. But so I think, let me see. Then also the other thing that we do, we don't leave a judge alone in court with one advocate. So there's all a two-counsel rule. So we sort of always know that, and this is for the propriety of the forum, to protect the judge, to protect everybody. We keep it so that there's always a, if I'm the if I'm the last advocate, then the one that finished prior to me will wait until I am finished. And you don't need to ask permission. You don't even ask to be excused, because you must wait. So don't excuse yourself. You must wait. Two advocates, two people in court. Maybe the judge excuses you or the magistrate excuses you because they want to finish filing or they've got other things to do. That is up to them. So they can do it. But I personally would know it's my obligation to wait if there's two of us. And I would only excuse myself if it is from the bench that excuse has arisen, which they do. They are not unaware of what's happening in the court. And if they leave you to sit there and they don't excuse you, it means they agree that you must be there. So, and then the other thing, like I highlighted earlier, if I stand up, the other person sits down. So that's how it flows. According to the Legal Practice Act Code of Conduct, there's no need to say, may I be excused? We don't do that in the High Court. And I see now this Code of Conduct is applicable in the Magistrates Court for candidate attorneys. So you would know that you can leave after the other, like you can move, because once the other advocate or attorney stands up, it means that your job is over. The only time you remain is if there's two people left and you are one of them. Then you can quietly pack your things without interrupting the court. You need to do it slowly and deferentially and not make a huge sound. So you need to not take the attention away from the advocate that is standing. You obviously don't walk in front of an advocate that is speaking or an attorney. You don't do that. You walk on the side. So I think, you know, in that entire court environment, you need to have that deference so that the judge is not disturbed or the magistrate is not disturbed. You don't read newspapers in the public gallery or while you're there. You don't, you tell your clients not to do that. You don't do things that distracts the judge. I am not perfect. We all make mistakes. We will be chastised. And the judges, the registrar will also point to you, your attorneys, if you not appearing, but if they are there, need to be properly suited. You need to fit the decorum of the court. Even if you're not appearing. So if you are a legal practitioner, you must be presentable and represent your clients. So to the best of your ability in terms of form and presentation. So I think in terms of the virtual requirements, if the matter, you need to look at whether this matter in the COVID pandemic, are there virtual rules that apply? What does this matter? Will it be physically heard? Will it be virtually heard? And if it's virtual, look at the directives, the practice directives for that court. So if it's virtual, there are things that are so basic. You must always update your software. You don't, like, you know, the Constitutional Court, I would tell you, go and have a look at their rules for virtual hearings, because really it is an excellent guideline. Their guideline may not be obligatory for other courts, but even on our high courts in Gauteng, there would be guidelines. Look at that. And each type of hearing would have its own guidelines. But the basic premise is that, you know, ensure your devices are charged or they're plugged in. What I have is I made sure I have a cable that runs into my router, because if it's a Wi-Fi without a cable, the transmissions can affect it a bit more. But if it's a cable, I think they call it there's Ethernet. If it's an Ethernet, then there's less disturbances. So for my accessibility, I have researched and I've made sure that I learn. The technology changes daily. So speak to tech-savvy lawyers or non-lawyers. Speak to them and say, this is what I'm doing currently. How do I minimize the interference? And they would give you tips. We all have tips. I don't know what I know without asking and seeking help, because I'm not trained on technology. In this forum that we are very fortunate that Schindler's Attorneys is assisting us with their technical personnel to ensure that we had a little bit of training on how to present adequately. So if you are heading to court, do a practice run. See with your team. If you have a witness, see if the witness has the right application downloaded. What application is the court using? Is it Teams? Is it Zoom? Do you want to have a practice session? Practice sessions are the only way. And then you also need to know that your background. You know, the courts have in the Constitutional Court, they've expressed how they want the background. They've expressed certain things. So those may not be applicable to us in the High Court or in the lower courts, and many matters in other divisions are physically heard. But I think as long as you know to see what that court requires, then what that matter requires, what your setup is, how do you practice run, what do technical IT experts advise, and then implement, then you know you've tried your very best. It was very painful for me to start addressing everybody online because I've grown up in a different way. The advantages you will have is that you are way more tech savvy, and that your training, your youth, your development is incorporating technology. So it will become part of your psyche. It will become part of how we do things and how we ease the way. So I think what I did, also security, you need to be very aware, because as lawyers, you need to protect legal professional privilege. We are not allowed to make the mistakes that others make, because these are clients' rights that are highly privileged. And what is very important to know, I mean, legal professional privilege is sacred. It is so protected. So the court can order that a medical practitioner make available certain information in order to ascertain the truth, but legal professional privilege is highly sacred. So when you are interfacing, you must determine which matters do you want to consult with online. Do you have the correct protective mechanisms in place? Or is this something that I want to consult with a face-to-face with a proper COVID protector? I will take that thinking into my deliberations. I would be very careful, because these are not my rights. These are rights I must protect. So you need to think about all of that, and there are ways and means. So I think from that, I have covered the best that I could in terms of appearances. And what I want to say is that the final way for appearances is really in court. The best training is mock appearances. Thank you, Hilda. You want to address it?
Advocate, thank you so much for all your information. It really helps a lot. I have just been informed, however, that Advocate Naidoo requires quite some time. So are you ready? Can we move?
Yes. What the way I would propose is that I have concluded the appearance section, is that Advocate Naidoo can proceed, and then if there is time, then I will continue thereafter. Thank you.
Thank you, Advocate.
Hi, thank you. Good morning, everybody, or good afternoon now. I know a lot of you feel very, can you see me now? I know a lot of you feel very skeptical about your future as lawyers, and Advocate Tiry has given you more than an insightful talk as to what to expect. Just one or two things, to elaborate on what she said, is when you address a judge or magistrate in chambers, it's different from how you address them in court. We do differ on how you address a magistrate. Some say call the magistrate magistrate. I have always called the magistrate Mr. or Miss in court, and your worship, Mr. or Miss in chambers, and your worship in court. With the judge is referred to judge in chambers, and your worship or your lordship, or my lord or my lady in court. A soft point is about robing in the High Court or in any court. Sometimes you do end up in court and you realize the magistrate or the judge suddenly walked in and you're not robed. So what you need to remember here is to leave the court, robe outside, and then come back into the court. Also, you need to inform your client of the court rules so that your client who is in attendance will also comply with the court rules. So that's just a little extension that I needed to add on to Aisha's talk. And I know we rudely interrupted her. Now, firstly, I must congratulate you on your career choice. You know, a career in law is very demanding, but it also is very fulfilling. It requires you to read, learn, and increase your knowledge base all the time. it's not only to increase your knowledge base and fulfill your life in your career, it's life in general. So it would be abnormal if you were not anxious and skeptical. But what I encourage you to do is that one shouldn't look at your career choice as a job, but rather a journey that you commit to. And on the way, you find your passions as you go along. So in the next half an hour or so, I'm going to deal with certain aspects relating to family law and bail. I have been an attorney in 1998 to 2001. And then I joined the Office of the Director of Public Prosecutions in Johannesburg. So I have the benefit of being an attorney and having prosecuted in the High Court and in the lower courts for a long time. So firstly, I'm going to deal a little bit with virtual hearings. As we all know, this pandemic has taken the world by storm. As a people, we are very resilient, and we found alternatives to traveling and face-to-face interactions. So some courts have been conducted by means of virtual hearings. The district and the regional courts are running in person, so you appear in court when your matter is in court. The South Gauteng High Court, the civil matters are being conducted via online platforms, that's Zoom and Teams. If you are not familiar with these platforms, please familiarize yourself with them. The criminal courts, however, are conducted in person. This is because the accused who are in custody needs to be brought to court, and those that are out on bail need to present themselves before a magistrate or the judge. Prior to the pandemic, there has been infrastructure in place for postponements to be done via audio-visual link. So this infrastructure was in place. So don't be surprised in future if criminal matters also move to the online platform. In the North Gauteng High Court in Pretoria, you have to speak to the judge's clerk. Like Aisha said, everything goes through the judge's clerk or the registrar to ascertain whether the judge will be amenable to having an online virtual hearing. So when matters are heard virtually, the link will be provided to you as an attorney by the judge's clerk. If you've briefed counsel, please furnish your counsel with the link. Be dressed in your court attire, and it will be useful to also keep yourself available if you've briefed counsel. So if counsel needs to take a quick instruction from you, you will be available and you'll know the issue that has arisen in court. Also, make sure that your background is plain, it's free of clutter, and there's nothing distracting to the judge or the other attendees. When you log in, turn off your video, turn off your sound. And when your matter is called, that's when you activate your video and unmute yourself and proceed. Make sure that you have everything you need at hand. If you need textbooks or your legislation, case law, your documents, just make sure you have everything you need so you don't have to wake up from where you are. To ensure that you're confident and ready to for court, your preparation, like Aisha mentioned, your preparation must be done properly and competently. And as I go along, you'll also hear me refer to competence of preparation. Now, let's deal with divorce matters in general. This is part of the family law portion of my talk. As an attorney, you will be approached by a client either to institute divorce proceedings or defend divorce proceedings. Now, in the main, we will deal here where you are instructed to institute divorce proceedings. As many of you might already be aware, clients seeking a divorce can be very long-winded. They need to be heard, they need to be understood, and they need not to be judged. That is very important. So they also need to be competently advised. So sometimes you might find that the law does not favor the instruction of your client. This is where you need to be forthright to tell your client what his or her position is. So that's where your competent advice will come into play. You must also remember that this is the very client that may have other legal issues, who is going to come to you on other occasions. So you need to build this confidence in your client, so your client will feel confident enough to come to you with other legal issues as well. You also must remember, time is money. If you reverse the roles and you were the client, you will also want proper value for your money, good value for your money. So it's incumbent upon you to also give this to your client. So although the first consultation in a divorce matter can be very entertaining, your intention is to obtain the relevant information for the first step in the litigation process. And what is that? That is to draft your summons. So you might need the names, the addresses, the employment details, the marital regime, marriage certificate, copy of birth certificates, any documentation relating to property, maybe an antenuptial contract. So whatever you need, make sure you tell your client that this is what you need at the first consultation. You must remember that your client doesn't know what is essential for you to put into the particulars of claim. So through all the chatter and the noise, you've got to elicit what is important. You are the legal practitioner, you know what is important. When your client leaves, you must have elicited all this important information so that you can expeditiously start preparing your summons. You must agree with me when I say that it would be very unprofessional to contact your client at a later stage and say, I forgot to ask you for this or that document. Or if you forgot to ask for a marriage certificate, for example, the client might need an opportunity to rearrange one, a replacement, because they might have been married for so long, it might have been lost, or whatever the case might be. So give them that opportunity. Don't create unnecessary stress over and above what they are going through. So if the parties agree to a divorce, you will be required to draft a settlement agreement, which might have to be endorsed by the family advocate. So there are two ways that a matter becomes unopposed. I would have asked you to tell me in the chat box, but because we are limited on time now, I'll proceed to tell you that a matter can become unopposed by agreement or the expiration of the days allowed for in the summons, which is 10 days. So after the 10 days expires, you may apply for a date on the unopposed role. Now, the unopposed role, the matters are set down on specific days of the week. So these are the days you will be informed by the registrar, which days the unopposed matters are being heard. Also, remember that it is the duty of the attorney to index and paginate papers. It is easy to make a mistake. And so please just check and double check so we don't irritate the judge. Also, documents are now being uploaded on Caselines. So this is an online platform. If you haven't familiarized yourself with this, please also familiarize yourself with Caselines, as it is the responsibility of the attorney to upload these documents onto Caselines. Even if you instructed counsel, the attorney has to upload the documents. It can also be very confusing as to where the documents should be uploaded. So if you're familiar with the system, you will get it right. So now that we've dealt with unopposed divorces, opposed divorces can be dealt with in two ways. It can either be mediated or it can go to trial. If it is mediated, and the end goal of a mediation is to come to a settlement. And once you obtain a settlement, that settlement agreement can be made in order of court. You also have to remember, if there are children involved, then you might have to it has to be endorsed by the family advocate. You've got to comply with all the procedures that's required. Also, if the matter goes to trial, then you need to make sure that your pleadings are in order. Once your pleadings have closed, pre-trial procedures have been complied with and completed, and that is only when you will get a date from the registrar. Also, you need to familiarize yourself with interlocutory procedures like Rule 43, and I think it's Rule 58 in the Magistrates Court, where you can apply, where you can, yes, make an application for interim maintenance and contact and care, that kind of thing. So you need to be familiar with what else would be required of you in a divorce matter. So just to summarize, you need to know that you might be required to draft a summons and a settlement agreement if both parties agree that the matter would be unopposed. Settlement agreement might have to be endorsed by the family advocate. If the days in the summons have expired, the matter also becomes unopposed. You can apply for a date on the unopposed role. That will be on specific dates of the week. Indexing and pagination has to be done by the attorney, and then your brief can be handed over to your advocate who will represent the client. Also, if the court is satisfied, the divorce will be granted. The settlement agreement will be made an order of court. Then it is up to you to uplift that court order and send it to the parties. So I think a lot of people generally forget that, you still have to go one further step, obtain the order and get it to your client. Don't just assume that your client knows. Okay, that concludes my bit on divorce matters. I think I can now move on to bail. Okay, so with regards to bail, bail is inherently urgent. The reason for this is because every arrested person is presumed innocent until they're proven guilty. Since an arrest impacts directly on a person's liberty, and that person is presumed innocent, bail proceedings become urgent. Now, the applicable section to bail in the Constitution is section 35(1)(f), which reads that every person who is arrested, or everyone who is arrested for allegedly committing an offense, so there again, allegedly presumed innocent, has the right to be released from detention. Now, this is not an untrammeled right, because if you read the rest of it, it says, if the interest of justice permit, subject to reasonable conditions. The Constitutional Court case of Gladwin-Wood and Skittercut, it emphasized that the section itself limits the right of the accused to be released. It's not an untrammeled right to be set free. It's only if the interests of justice permit and subject to reasonable conditions. The effect of bail. The effect of bail is that an arrested person is released from custody upon payment of a determined guarantee or amount of money to ensure his court attendances until the matter is finalized. So the matter can be finalized in many ways. The charges can be withdrawn. Some of the charges can be withdrawn. The matter can proceed to trial and the accused can be sentenced after being convicted, or he or she can be acquitted. So there's many ways that a matter can be finalized. Section 50 of the Criminal Procedure Act deals with postponement of bail proceedings. Now, it is important for you to familiarize yourself with the provisions of Section 50. So you won't be caught off guard if the prosecutor suddenly applies for a postponement. You'll know whether to oppose the postponement or not, whether your opposition will be reasonable or not. You need to know the circumstances under which a postponement can be requested. And in terms of Section 50, this can be done by postponing the matter 7 days at a time. And here again, the time limit will tell you that bail proceedings are inherently urgent. It needs to be finalized as speedily as possible. So I'm Section 56D that deals with when you can apply for bail proceedings to be postponed. I'm not going to go through that with you. You can read it, but it is very important for you to know. So if you're going to be doing criminal work, my advice to you is the following. Build a good reputation for yourself. This builds on what Aisha also said to you. When you start off, you want to prove yourself. You tend to develop an attitude. You don't realize it, but it happens. It just happens. But concentrate on building a good reputation. Always be respectful. When you develop respect for the court, your client, your colleagues, you show respect for yourself. Build good relationships with the police. Now, I will come back to your relationships with the police and you will see how important this relationship is. Do not compromise your integrity to win a case. Always be well prepared and have a good argument. Like Aisha said, critical thinking is important. If you are able to look at a docket and analyze it and think critically, you will come up with a good argument. That is what the practice of law is all about. You will. So have a good argument, and that is the best you can do for your client. So be honest, be careful, and be smart. Having said that you should build good relationships with police officials, you need to bear in mind that police officials have a very powerful position. Not that we should be intimidated by this, but we don't want them to frustrate you because you just annoy them. You will receive much more assistance from the police if they know you're smart enough to deal with your case and with how to, if you know how to represent your client, and that you don't unnecessarily throw tantrums, that you play the person instead of the ball, you know, then that won't sit good with them. They take advantage of the situation. Once you know how to represent your client properly and competently, you are in that powerful position. So in criminal matters, the investigating officer plays a pivotal role. You will have to deal with him or her at various stages of the criminal investigations and the trial. You might want to be present when your client is taken out for certain investigations. For example, your client is taken out for a pointing out. You might want to be present. Your client is taken out for an ID parade. You might want to be present. So that is why it is important to maintain an amicable relationship. You don't have to be extremely friendly. You just need to be amicable, polite, and respectful to the police officers, and you will get that help in return. So also your conduct will also have an impact on how the criminal justice system functions as a whole. We want the system to function efficiently, so all of us can benefit from this when we attend courts. So it is also important when you receive an instruction to do a bail application, you need to know, you need the CAS number, CAS, not CASE, CAS. That's a reference number for the police docket. It's called a CAS number. You need the police station, and you need the investigating officer's contact number, preferably a cell phone number. Detectives or other investigating officers are hardly ever contactable on a landline. So if people want to give you a landline, ask for the cell phone number. Section 59 of the Criminal Procedure Act deals with bail. It's police bail. Now, police bail may be granted to an arrested person before they even appear in court in the first place. This can only be done by officials with a certain ranking and above, or of a certain ranking and above. But this has to be done in consultation with the investigating officer. So often this person would be of higher ranking than the investigating officer, but they have to do this in consultation with the investigating officer, and you don't want a discrepancy with the investigating officer. So here again, be nice, be polite. Now, police bail is only granted in respect of minor offenses, such as theft, receiving of stolen property under 2,500 Rand, common assault. Common assault is not a crime in itself, it's assault, but it's less serious. It's not like your assault GBH. Possession of dacha less than 115 grams. These are the kind of offenses where you can ask for police bail. Once bail is determined, the amount is paid at the police station. You will receive a receipt. On that receipt, there should be the next court date when your client should appear in court. Bail is enforced, but once the accused appears in court, the court may impose certain conditions. So I also wanted to give you an opportunity to tell me what would happen if police bail is refused, or what are your options. But I'm going to tell you, just to shorten my segment of this. Basically, if police refuse to give you bail, you approach or you arrange for a hearing before a judge or magistrate, depending whether the matter is to be heard in the High Court or the Magistrates Court. As young practitioners, I think you would mostly appear before a magistrate. So your arrangements will have to be in accordance with the procedure at that magistrate's court. Section 59A deals with prosecutorial bail. Now, this is where the Director of Public Prosecutions or an authorized prosecutor by the Director of Public Prosecutions, in consultation with the investigating officer again. There's this irritating investigating officer always rearing his head, but the investigating officer won't be so irritating if you have this good relationship with him or her. So they can be very annoying at times. Maintain a good relationship, be polite, swear them in your mind, but be polite. Don't be rude to them. It's very easy to be rude. It's very easy to be impatient, but you can get a lot of assistance from them. Prosecutorial bail can be authorized in respect of Schedule 7 offenses. Now, I'm not going to take for granted, because I know there's candidates and young practitioners on this platform. Schedule 7 offenses refers to. If you look at the Criminal Procedure Act, at the back of the Act, after all the sections, there will be references to schedules, Schedule 1, 2, 3, 4, 5, 6, 7. So these are the schedules that are referred to in bail proceedings. So prosecutorial bail can only be granted in or authorized in respect of Schedule 7 offenses. This bail is only valid until the accused appears in court. When he appears in court, the magistrate can do one of three things. The magistrate can extend the bail on the same conditions. The magistrate can amend the conditions, or the magistrate can revisit the entire issue of bail and start the proceeding de novo. Then finally, we get to bail applications in terms of Section 60 of the Criminal Procedure Act. The general test for bail is that the accused must be released on bail if the interests of justice permit. We saw that also reflected in Section 35(1)(f) of the Constitution. Now, the burden of proof is on the prosecution, on the state. The prosecutor represents the state. The burden of proof is on the prosecution to prove on a balance of probabilities. That is, it's a similar test to civil matters. In your criminal trials, the test is proof beyond reasonable doubt. But bail applications, the standard of proof is lowered. It's on a balance of probabilities similar to your civil matters. So the burden of proof is on the prosecution to prove on a balance of probabilities that it is in the interest of justice that the accused be detained longer. So it's not that he be released, it's in the interest of justice that the accused be detained longer. Now, during bail applications, you can expect greater intervention from the magistrates during the proceedings. They might put questions to the accused or to you as an attorney or your counsel if you've appointed a counsel. They'll be able to request further evidence, and this is permitted in terms of the Criminal Procedure Act, which is Section 60, subsection 2. The procedure is slightly less formal than, or there's certain evidence that's more acceptable during bail proceedings, such as hearsay evidence. Now, hearsay evidence is defined in Section 4 of the Law of Evidence Amendment Act 45 of 1988. And it is defined as evidence, whether oral or in writing, the probative value of which depends upon the credibility of any person other than the person giving such evidence. So you all can breathe. It is not as bad as it sounds. It sounds like a mouthful, but when you break it up, it's much easier to digest. So it's basically evidence. It can be oral, it can be in a statement in writing. And the credibility and the value of that evidence depends on a person other than the person who's saying to the court, this is what happened, because the person giving evidence hasn't witnessed it, so does not have the credibility to tender such evidence. But this kind of evidence, it seems like an exception that this hearsay evidence is admitted in bail applications, because the general rule, and I don't want to get too much into this because it's a whole topic on its own, the general rule is that hearsay evidence is inadmissible. So now when dealing with applications in court, you need to ascertain whether the application will be opposed or unopposed. If it's unopposed, you may address the court without putting your client in the witness box. But what you need to remember is that even if the state or the prosecutor does not oppose bail, the magistrate can still deny bail to an accused. There is nothing wrong in inquiring whether a magistrate requires evidence. So if evidence is required, then you have two options. You either file an affidavit signed by your client, or you can put your client in the box where he can tender oral evidence. So if your client does tender oral evidence, then it's similar trial rules apply. He can be cross-examined by the prosecutor and re-examined by yourself or your appointed counsel. You must remember that in a bail application, the merits of the matter are irrelevant. It's irrelevant, but the strength of the state's case becomes relevant. So if an accused is likely to be convicted because the state's evidence is overwhelming and might be sentenced to a term of life imprisonment, then a submission can be made that the accused is probably going to be a flight risk, is probably going to flee. There is going to be a likelihood that he will flee. You'll see this a bit later. So whenever you file an affidavit on behalf of the accused, or whether you lead his viva voce evidence, you must comply with section 60 subsection 4 of the Criminal Procedure Act. So I'm just going to tell you in brief what section 60 subsection 4 says. It says that the interests of justice do not permit the release of an accused from detention if one or more of the listed factors are present. So it doesn't have to be all, it's one or more of the factors. And it would be where there is a likelihood, the word likelihood is used, where there is a likelihood that the accused, if he is released on bail, will endanger the safety of the public or any other person or commit a Schedule 1 offense. You don't have to worry about remembering all of this because it's all in section 60, subsection 4. Where there is a likelihood, if he is released on bail, will attempt to evade trial. So here, flight risk. Where he will attempt to influence or intimidate witnesses, or to conceal or destroy evidence. So you want to protect your evidence. You want to protect your witnesses. You don't want the accused to flee. If there's any way he will undermine or jeopardize the functioning of the criminal justice system, including the bail system, where he's let out on bail and now, you know, there's going to be reduced confidence in the bail system because now an accused is being granted bail and then he's going and committing similar offenses. Also, where in exceptional circumstances, there is a likelihood that the release of bail will disturb the public peace or undermine public peace or disturb the public order. So any one of these conditions that apply, then the court should deny the accused bail. What I need to tell you is that when evidence is given orally, it has more evidential weight than when evidence is given on affidavit. The Criminal Procedure Act also requires the legal representative or the accused to put forward any previous convictions that the accused might have and any pending cases. Now, these are obviously factors that must be left out of trial matters. So it's just for bail applications. I'm going to just add in something here, which I think it's important to know. Because the magistrate in a bail application has access to information that cannot be heard during trial proceedings, like pending cases and previous convictions, and maybe even the merits of the case or evidence regarding the strength of the state's case, that magistrate will not be appointed or allocated to hear the trial of the matter. So what I'm going to say next is very important. So I want you to pay special attention to what I'm going to say. Where an accused is charged with an offense in terms of Schedule 5. So you go to the back of the Criminal Procedure Act, you look at Schedule 5, and you'll see the offenses listed. The court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law. So in accordance with the law means in terms of the criminal procedure until the matter is finalized, unless the accused. Now, if you remember what I said earlier on, I said that the onus is on the state to prove that it's in the interest of justice to keep the accused detained. Now you're going to see a shift in onus. When it is a Schedule 5 offense, the onus shifts to the accused. So unless the accused having been given a reasonable opportunity to do so, the reasonable opportunity refers to a bail application. So unless the accused having been given a reasonable opportunity to do so, being given an opportunity to apply for bail, adduces evidence which satisfies the court that the interests of justice permit his or her release on bail. So here the onus shifts to the accused to satisfy the court that it is in the interest of justice that he be released on bail. Okay, that's Schedule 5. Now, put that in a little block. Next, we're dealing with Schedule 6. When an accused is charged with an offense referred to in Schedule 6, the court shall order that he be detained in custody until he or she is dealt with in accordance with the law, very similar to Schedule 5, unless the accused, having been given an opportunity to be heard in a bail application or bail proceedings, adduces evidence that satisfies the court that exceptional circumstances exist justifying or permitting his or her release on bail. Now, you can see the difference. Schedule 5 refers to the interests of justice. Schedule 6 refers to exceptional circumstances. But in both Schedule 5 and Schedule 6 offenses, the onus shifts to the accused. So there's a greater burden on the accused to ask for his release. After all the evidence is led by the accused, both the state and the applicant, because in a bail proceeding, the accused becomes an applicant, he applies for bail, will get an opportunity to address the court by way of argument. So the prosecutor will address the court, or the applicant will start, you or the counsel will address the court, and the prosecutor will get a chance to reply. The magistrate will give a reasoned judgment for the granting or refusal of bail. Now, the person who is responsible, if your client is let out on bail, the person that is responsible for ensuring that your client complies with his bail conditions, whether it's signing in at the police station twice a week or whether he is under house arrest or whatever, is the investigating officer again. So we don't want this investigating officer to cause unnecessary problems for your client because you irritate him or her. So if bail is refused, your remedy will be to take the matter on appeal, and your appeal will lie to the High Court. When bail is granted or refused, or your bail appeal is refused, that is the end of it. You cannot bring a new or a fresh bail application unless bail is cancelled or revoked, or there are new facts. There are new circumstances that can be established to justify a fresh bail application. Okay, so that is basically what I want to tell you on bail. So it's important to ascertain which schedule your bail application falls under. And remember, in terms of Schedule 5 and Schedule 6, the onus reverses to your client. So it's either in the interest of justice or exceptional circumstances. Please do not make up exceptional circumstances. Look at case law, see how the courts view exceptional circumstances. And this is not to fabricate evidence, it's to elicit information from your client to determine whether the court will see his circumstances or her circumstances as exceptional. Like I said, do not place your integrity on the line for a client. You also have to remember that you're not entitled to a copy of the docket at this stage. There are circumstances that you might request certain information, but like Aisha said, we're not going to tell you everything. So you can go and do your research as to when you can request certain sections or certain statements during for a bail application. And also the investigating officer usually files a statement if it's in opposition to bail. Then you can glean from that the strength of the state's case and what the evidence against your client is. So also remember, when you're drafting your affidavit or leading your client, section 60, subsection 4, you address all those factors. Why your client is not a flight risk, why he's not going to intimidate witnesses. You just go through all of that. And don't forget, it is important, you have to advise the court of previous convictions and pending cases. So also with regard to what Aisha said, the file that you need to have in your mind. Bail applications are inherently urgent. When you get an instruction to do a bail application, you don't have time to prepare. This is your opportunity to prepare. Today you have prepared for your next bail application. So you know, if you get a Schedule 5 bail application, this is what you have to prove. Schedule 6, this is what you have to prove. So what I suggest to you, whether you have a file online, a file on your computer, or you have a physical file, the older people like a hard copy documents. So, and I find it very easy to refer to. You just pull a file out of wherever you keep it, and you've got your section 60, you've got your section 35 of the Constitution, you've got your case law, you've got your schedules, everything that you need for bail. So you might also have other affidavits that you've drafted in the past. So you know exactly what you need. You're not going to, like with the family law matters, you know what you need to ascertain from your client. So also you can have a checklist if you want. Have a strategy. Don't just follow the herd. Have a strategy. Think critically. Develop systems for yourself. The same system is not going to work for everybody. Be innovative. You know, it really will help. It really will help. It will help with your reputation, your credibility, your performance, and your career in general. Like I said, view it as a journey. Find your passions, enjoy the journey. I know law is generally very serious. There's not too many jokes you can tell about it. But at the end of the day, it is really a very fulfilling career. Hilda, if I have more time, then I could go through an example, but I think I've covered it.
Yes, thank you, Advocate. I think we have covered it. I think we should definitely get you and Advocate Tiry in for separate, separate Zoom webinars to go into more intricate levels of this whole situation, especially with the bail. I know I learned quite a lot because I don't do criminal law, and I had to do a bail application for the first time the other day. So I have to say I learned quite a lot. So we will definitely have to look into doing a separate one at a later stage. Thank you.
Can I just say one more thing now that you raised this, Hilda? Don't be afraid to brief counsel if you find it overwhelming for you, especially at this stage of your career. You know, experience teaches you a lot. These are the foundation, the building blocks. You need so much more when you appear in court. That is why I say read, learn, increase your knowledge base. So also when you have counsel, you accompany your counsel to court. You frequently giving your counsel instructions. You will learn so much. And that is the important thing in this profession. You need to learn as you go along. Thanks, Hilda.
Thank you so much, Advocate. We will now proceed to our chairperson at the Johannesburg Attorneys Association, Mrs. Chantal Gladwin-Wood, to provide us with the closing of the of this webinar.
Good afternoon, everyone. Hilda, thank you for that introduction. My name is Chantal Gladwin-Wood. I'm the current chairperson of the Johannesburg Attorneys Association and the Gauteng Attorneys Association. And I'd like to apologize for my little man who's just decided to pop into the background here. I happen to be in very rural KZN, and the only spot that I can find with signal is outside in the garden, and I'm being eaten alive by ants. So please excuse me for the brevity of my statement today. But in terms of women practitioners in particular, we are nothing if not adaptable and ingenious. And that is one of our best weapons, is that our infinite capability to love and to teach is something that sets us apart, I think, from our male colleagues. Right. So, sorry about that. We really are being eaten alive by ants. I'd like to thank everybody. This webinar has been absolutely phenomenal. The knowledge, but not only the factual knowledge and the practical knowledge, but also the but also the emotional intelligence that has been imparted today is phenomenal. I think, Hilda, I'm going to hand over to you because I've lost the ability to continue this presentation for technical reasons, as you can see in the background. So Hilda, I'll let you do the closing. Thank you.
We would like to thank you, everybody, for being with us today. And thank you to SABWiL for giving us this opportunity to do a thing with you as well today. We have really enjoyed doing a webinar with another association with other views and other ways to do stuff. It has really made us open to other ways of interpreting the webinars and doing stuff and doing our social media, etc. And we would also like to thank all our speakers today, as well as the ladies who are and the attendees for taking the time on a Saturday and for coming in today. President Cleopatra, I don't know whether you would like to say a closing. Thank you.
Always, always, Hilda. What an amazing way to honor the Imbokodos of 1956 during the year of Charlotte Maxeke. I mean, wow, how amazing was this? We are truly grateful to our modern day Mbokodos, Advocate Aisha Tiry, Advocate Naidoo, for imparting such wisdom and information and education on us. We are wiser for it. We are more knowledgeable for it. And I think I speak for everyone when I say I think going forth, we are going to be slightly more confident as we go on with our daily duties because of the knowledge that you imparted. We are eternally grateful. Thank you, thank you, thank you. I shared the social media handles in the chat box. I hope that everyone took note. Please do follow both the JAA and SABWiL on social media. And also, I think from my side, I'm really happy. I think I neglected or I forgot to apologize for Advocate Zandile Kono. She couldn't be with us today because of circumstances beyond her control, but she really wanted to be here. And I know that she is completely cut up for not being here, and we will tell her everything going well. But thank you so much for being here. We really appreciate you. Enjoy your Saturday.
Watinta Bafazi, Watinta Mbokodo. Enjoy. Bye-bye.
Bye.
Bye, everyone.